Hi, I'm Claudia St. I'm the president of Affinity HR Group. We are your HR partner and resource. In January of 2023, the Federal Trade Commission issued a guidance rule that they intend to roll out that basically creates an entire ban on non-compete agreements or clauses or provisions. This is currently in review form. It's open to public comment, and then it will be subjected to lots of wrangling as to whether or not the FTC even has the authority to issue this rule or enforce this rule. So this is a very early stage of evaluating what happens with non-competes. But it should be something that employers are paying attention to. Currently, non-competes are generally regulated by state law. That said, courts have weighed in on such covenants over the years to create some general guidelines of permissibility that make them enforceable. For example, most non-compete clauses have to have a term limit. So you can't work in the same industry or compete against your current employer for maybe 6 months up to 2 years. They also usually have a geographic footprint, so within maybe 10 miles of the current employer, maybe 20 miles of the current employer, and they usually have to specify scope. So for example, if I work in manufacturing soap, does that prohibit me from working in manufacturing pharmaceuticals? So all of these things are broad regulations that exist today. This rule, as it's being issued, would pretty much prohibit non-competes across the board on a federal level. Now, many states have put a lot of restrictions on these covenants. For example, California, North Dakota, and Oklahoma all have a near complete ban on the use of non-competes in employment. And if you listen to those three states, California, North Dakota, and Oklahoma, that might indicate to you that that's a pretty bipartisan perspective. And what we know is that the use of non-competes increasingly have been extended beyond C-suite employees or knowledge workers that have trade secrets or top sales professionals, down to the very rank and file service workers, such as those that would work in the fast food industry. So what the Federal Trade Commission says is that these covenants, by their very nature, prohibit an employee's right to work gainfully within their environment and within their specialty, and as such are an antitrust or an anti-trade effect, have that effect. So what they're hoping to do is eliminate these altogether. If they do, they would prohibit not only any future non-compete agreements, but all existing non-compete agreements. So it's important for you to take stock of what non-compete agreements you have. If you have them, look at them and have them reviewed legally for their permissibility or enforceability as it stands today. I find many non-compete agreements that I have looked at are so overly broad or so overly long that they would likely be unenforceable in the court of law anyway, and a lot of employers know that. They issue them despite that, just to create some kind of a barrier, some kind of a threat from an employee leaving and taking either their own knowledge or some secrets with them. So what's an employer to do? Well, the reality is it's a good idea to look at these covenants and look, are there other things that you're trying to accomplish that don't prohibit an employee's right to choose another job? For example, having a good confidentiality agreement that specifies what is confidential information and what cannot be disclosed, such as a non-disclosure agreement, which shows what information should not be disclosed. If it's already not public information and can't be accessed any other way, you can prohibit an employee from releasing that information. There are other aspects such as non-solicitation, and those non-solicitation clauses can mean that an employee won't solicit the companies that are the clients of the existing employer should they leave, or won't call into the company and try and woo away some of their coworkers to come and work with them somewhere else. The current rule doesn't specify what it would do with confidentiality and NDA and solicitation agreements. However, I suspect if those non-solicitation agreements encourage an employee not to reach out to other existing employees for other job opportunities, that may be suspect as well. Whatever happens, take a look at this law, take a look at this rule. It's currently in public comment period. If you have feelings about it, share them one way or another. But I just want to remind you, the best way to keep a happy employee, to keep a productive employee, is not to restrict them with a covenant, but to focus on creating a happy and well-engaged workforce. And if that's what you're looking to do, reach out to us at Affinity HR Group. We are here to help. With any questions, don't hesitate to reach out. Of course, if you like this information, please share it. Please follow us on all of the social media platforms. And if you have any questions, don't hesitate to give us a ring. But that's it for now. We hope you have a safe and productive work week. Take care.